between the different types of leases, because that is definitely first and foremost going to kind of drive the different options that are available. Not that there are different options necessarily for, requesting maintenance, on a unit, or, having some sort of negotiation for your rental rates or things like that. But the comfortability of a tenant to actually engage in these conversations with a landlord can be very dependent on if they have a month-to-month tenancy versus a one-year tenancy. And we'll kind of talk about the differences between that and why the dynamics might be a little bit different there. Then we're going to talk about, if something actually does happen and the courts get involved, what does that timeline look like? Because in Kansas, as you guys probably know, it's pretty different than Missouri or Oklahoma. Kansas is definitely a fast track state as far as, making sure that these things get in front of judges. And if there's going to be a trial setting, that happens sooner rather than later. Then, kind of in the backdrop of that, we're going to be talking about the different obstacles that tenants may face in court, whether that's, understanding procedure or making sure that they have all the available or necessary information with them to be able to kind of articulate what's going on with them. And then with that is procedural defenses as far as like notices and things like that we'll talk about as well. And then we'll talk about compulsory counterclaims as far as, what you do if you do find yourself living or you find a tenant living in, some pretty deplorable situations or things that, should be getting fixed that aren't being fixed or things like that. How does that come up and how does that interplay, with a trial setting or if the court is involved? And then hopefully we'll still have some time for Q&A. But like I said before, this is not your one phone call with KLS or anything like that with us. If you do have questions, I want you to know that our time is not just limited to this morning, that we are happy to be available for you in any way that we can. So here we go. All right. So the lease. It's very important to remember, okay, that there is a playbook, so to speak. That's what I like to call it. It's not just whatever is in the four corners of your lease document is the terms of that contract. Now, certainly those terms in that lease agreement itself are incredibly important and very informative, and they set up a lot of the building blocks for that relationship. But it is so important. I'm getting really excited here because this is really important that if anything you guys take away from this time that we have together, and hopefully you already know, that Kansas has this awesome set of laws known as the Kansas Residential Landlord and Tenant Act. I know that my camera's probably not going to focus in super well on that, but just know that there are a set of statutes that the state has passed that governs every single residential lease agreement in the state of Kansas. And beyond, and it goes on, as far as defining the duties of both the tenant and the landlord, what they can and can't do, how those lease agreements are supposed to be terminated, how they're supposed to be modified, how much a landlord can charge for security deposits. It's not the most expansive, rule of law that there is in the country, but for Kansas and for tenants here, this is a wonderful tool, and it's a wonderful, backdrop and kind of a safety blanket, because any agreement that is in Kansas for a residential lease has to be in compliance with these statutes. So even if it's not in the actual lease agreement itself, maybe it's just like a one-page lease agreement. It's not the, 10-page document of statutes that I have here. All of those statutes apply, and they are read into every single lease agreement in the state of Kansas. None of these rights or privileges or remedies available under the Kansas Residential Landlord Tenant Act can be waived inside the lease agreement itself. So there can't be any terms that say, that the parties agree that, the terms of the KRALTA, that's kind of what it's abbreviated as, won't apply. Those are not enforceable in court. And there's actually penalties if there are efforts by a landlord to kind of try to sidestep the protections of the Kansas Residential Landlord and Tenant Act that a tenant can request from the court in the event that, the landlord, knew that they were doing that for the purpose of trying to skirt these protections. Okay, so now that we kind of have like our backdrop set as far as like what we're going to be talking about and how these kind of things fit together, let's talk about those differences between the month-to-month versus a one-year lease. These are the most common types of tenancies, residential tenancies that we see. And they both serve different purposes. And so what I'm about to say about month-to-month tenancies should not be meant to like disparage or to say that, they're awful and that people shouldn't ever be on them, because that's just not true. But what is true about them is that a month-to-month tenancy does have fewer protections for a landlord and a tenant than a one-year lease does. And what I mean by that is that on a month-to-month lease, each month auto renews as its own lease contract. Okay. So either party can terminate that month to month lease with a valid 30-day notice. As long as that's tied to a rent paying day, either party, the landlord or the tenant, can terminate that agreement, that rental agreement, as long as the notice is valid. There doesn't need to be any kind of non payment of rent dispute. There doesn't need to be any kind of malfeasance or any kind of wrongdoing by either party. The only thing that needs to happen in order to terminate that type of lease is a valid 30-day notice that's tied to a rent paying day. And I'll get a little bit deeper into like how that actually looks in practice here at the end of my presentation. But that's just something to keep in mind versus your 1-year lease agreement, which is set for that full period. And generally, those can only be terminated unless there's some sort of an agreement between landlord and tenant to terminate it earlier. Generally speaking, those can only be terminated by, a non-payment of rent, 3-day notice type of dispute, other type of, a 1430 type notice, which again, we'll get into these types of notices later. Or if there's like some sort of like a termination date or something like that at the end of the lease agreement, and the tenant or landlord chooses to exercise saying, hey, we're not going to renew this. That's kind of important to keep in mind too, because and I'm sure that you guys have probably seen this as well, where maybe you're talking with a tenant who has been living in a unit for like ever, like 5 years, 10 years, and they're, they've never maybe signed a lease agreement beyond the first one that they signed. And they think, oh, well, my lease just auto renews on a 1-year basis. If that's the truth, then that's great. But in Kansas, something to keep in mind too is that if there's no terms in your lease agreement that specifically say that this agreement at the end of the end date, for your 1-year lease agreement, let's say that starts on March 1st, 2026 to end on March 1st, 2027. If that lease agreement doesn't specifically have a term in it that says, at the end of this agreement, at the end of this lease term, it will automatically renew for a new 1-year period. If it doesn't say that, then it will auto renew on a month to month basis. Okay, so that's kind of how these things fit together here, where if people are living in places for more than a year and they haven't signed a new lease agreement after the conclusion of their first year, odds are they're probably on a month to month tenancy.
And Chris, we have a question in the chat.
Sure.
Can a lease be longer than 1 year, like 18 months?
Yes. Yes, it just has to be in writing. And that's a really good question. I haven't seen that particular arrangement before, but that is certainly something that a landlord and tenant can agree to as long as it's in writing. And the reason it has to be in writing, just a little behind baseball here, there's a different set of laws called the Statute of Frauds. That one of the concerns there, that's the doctrine that says, hey, these kind of agreements need to be deduced in writing in order to be enforceable in the court. And one of those things that falls into that is contracts that cannot be completed within a 1-year basis. So if it's an 18-month lease, and that's the lease term that the parties are agreeing to, then as long as it's in writing, then yes, that can happen. And if the terms specifically provide that it will auto renew on a new 18-month basis, then that's what it will do. But absent any kind of renewal language in an existing lease agreement, the default per the Kansas Residential Landlord and Tenant Act is that it will automatically renew on a month-to-month basis. Okay, so then the other little ditty to kind of keep in mind here too is that security deposits that are provided in your lease agreement. We've been seeing, not so much here recently, but when I first started, we were seeing all sorts of lease agreements that would say, we want first month's rent and last month's rent as the security deposit. So, 2 months worth of rent. That's not actually enforceable unless there is a pet It's not enforceable unless there's a pet and the landlord is providing a furnished unit, which I have never seen a furnished unit in Kansas City. I'm sure that they exist. But the default, base, rate that a landlord can charge for a deposit, a security deposit, is 1 month's rent. And so that's something to kind of keep in mind too, that, if there's any deductions or anything that the landlord wants to take out of that security deposit, they have to give you an itemized list after you move out. And they have to have the list has to have the deductions as far as where's all the money going to? It can't just be a bill that says, yeah, we took all $500 of your deposit to do, to fill holes and to replace those crappy little the 10 things that are underneath the heaters on all of your ovens or the burners. I always ended up having to replace those in every rental place that I lived in. So um not spiteful at all. But being that as it may, just keeping that in mind that there are set things in here that are going to govern how much landlords can charge and the manner in which if they want to retain any kind of a security deposit. Something that I want to kind of also hit on too is that if there's any sort of agreement in your lease or in any tenant's lease that says, hey, by paying the deposit, you automatically agree that we're going to be able to take $200 out of the deposit to pay for carpet cleaning. That's not something that they're allowed to do either. That's a liquidated damages clause. And that's not enforceable. The only reason or purpose that a security deposit can be used to apply or for deductions is if there's actual damages caused by a tenant or things that are beyond the normal wear and tear. That's been getting a lot of mileage here lately as we're kind of deducing like what is normal wear and tear. My favorite example to kind of illustrate this is if you live in a one-bedroom apartment and you have that one hallway that connects everything. The hallway has the bathroom, the kitchen, the living room, and your bedroom right off of it. And that's like where all of the foot traffic for that apartment is going to take place, right? You're coming and going, you're moving and grooving. But if after 2 years that you live there and then you're ready to move out, it would make sense that, maybe your carpet has a rut in the middle of it from you walking, you coming and going and using the carpet as carpet. You're just walking, you're not doing anything else beyond, living in your unit. Well, it wouldn't make sense for the landlord to be able to charge you, costs to replace the carpet because you were just using the carpet for its intended purpose. Now, where it gets a little different though is if you have a dog or if you are having a bunch of parties or something and you're spilling stuff on the carpet or you have an animal that's chewing it up or what have you and you're causing actual damage to that carpet, then it would make sense for you to theoretically be liable for the replacement of that carpet. So I know that's kind of like a nuanced thing, but something to keep in mind because we see a lot of built-in fluff around these security deposit claims or clauses in lease agreements themselves. Okay. All right. Well, actually, let me back up here. So before we even get to an eviction timeline, I did want to touch on pet deposits here too, because this is something that we've been seeing a little bit more about as well. There's not a separate statute for pet deposits. It's all wrapped into the exact same statute that governs general security deposits. And so I think that there's a legitimate question here about, a landlord's ability to charge an additional half month's rent for a security deposit related to a pet, but then claiming that that's just straight up a non-refundable pet deposit. So keep that in mind too. I know that that's just kind of popped into my head here, but that's something to be on the lookout as well if you're looking over lease agreements for tenants and they're concerned about making sure that they get all their money back. That is something to kind of flag that I do not believe that there's current case law that kind of governs that. However, just with how everything's laid out in statute, that is not something that I believe that landlords are in a position to say, hey, yeah, if you have a cat or if you have a dog, you have to pay the pet deposit and that deposit is non-refundable. That shouldn't be what the purpose of that is. So that being said, jumping back to our evictions timeline. So let's say you're working with a tenant and they find themselves with some sort of a notice or some sort of a court summons, alarm bells should be pinging off your head, and it should be pinging off the tenant's head as they're kind of working through, okay, where are we at in this process? Because in Kansas, things move so breakneckingly fast. So in Kansas, for non-payment of rent type cases, that's where you're going to see that common 3-day notice to pay or quit. That is the only notice that's required before starting that non-payment of rent-based eviction. And kind of like what happens here too, and something that I think a lot of people are maybe surprised about, is that anybody can theoretically, file a case against anyone. In law school, there was like some bad joke that a professor used to make about, you could sue a ham sandwich if you wanted to. But what's meant by that is that, if you go to the court and you fill out all the paperwork and you hand the clerk the filing fee and say, hey, I'm going to be filing an eviction case against Rhea because I don't know. I think that Rhea owes me money or something. I just feel like I like filing a case. Well, the clerk's not going to ask me to like prove that I own the property that Rhea is occupying. The court's also probably not going to ask me to supply a copy of the notice that I gave the tenant before filing the case, because that is something that has to happen before a landlord can pass go, is they have to issue this notice before they actually have standing to file the case. And we'll talk again about like what needs to be in these notices, why that's so important here in a second. But what I'm trying to say about, being able to sue anybody is that, the clerk and the court will just take the money. They'll make, they'll create a record that, hey, Miss, Chris Mo is suing or evicting Rhea Carter, excuse me. And, there's a case number, and now we're set for an answer hearing, in 2 weeks in the Wyandotte County District Court. There's no fact checking on the part of the court. This is a completely a civil action between two private citizens that are using the district court as the vehicle, to settle this legal dispute. And so that's something that is so incredibly important to keep in mind, because there is no expungement for an eviction case. Like once that filing fee is paid and that case number is generated and that summons is issued, there is the record of an eviction on somebody's record. Okay, so that is something to kind of keep in mind. Even if the case ultimately ends up getting dismissed or the tenant wins or what have you, there is still that record of a filing of an eviction case against that individual and in the district court's website that is publicly available. So that is something to keep in mind as you're talking with tenants, as you're talking about, where you're at in the different stages. If a tenant is actually being served with the summons and that they have a court date and time, well, then at that point, we're not talking about trying to keep an eviction from going on the record. It's already on the record. Now we're talking about a matter of controlling the optics of how that case is going to be handled and how that case gets resolved, because it looks a lot different for a tenant going to a new property manager or a landlord where they say, hey, you might see that there's this old, 2026, Wyandotte County case that was filed against me. Here's a copy of the judge's dismissal or the voluntary dismissal of that case that shows that I wasn't found, liable for anything. I wasn't removed by the sheriff. I wasn't actually evicted. There was just a case filed against me. But that was just a misunderstanding, and everything is fine. I have a neutral tenant rating or what have you. That conversation is so much easier for tenants to have than, oh yeah, I got evicted and I still owe that person $2,500, and you can see the judgment in case search if you were to just search my name. And so that's kind of something to keep in mind too, as we're kind of evaluating where tenants are at in the various court process and how we can best serve them by making sure that we are, like I said, controlling those optics and giving them that avenue to lily pad, hopefully, to, those greener pastures, or to, ultimately put up a big fight, to preserve those rights if we do believe that something is shifty as afoot. But keeping in mind, as far as like how this is going to be looked at by the next property manager or the next landlord or what have you, is important as we're talking with tenants as they're looking to us for advice on how to navigate this situation and just what those optics currently are if they're in that situation. So like I said, the court will, take your money, they'll create the filing, and they'll issue a summons. From that date, there will be an answer hearing 14 days after. Generally speaking, and that depends on like the scheduling of the court, but usually that's pretty steadfast as far as getting the limited actions people into the court. And that's the division of the court that handles evictions, is called limited actions. It's the same division of the court that does, debt collection, garnishments, really any unsecured debt that's under $25,000 is generally going to be handled in limited actions court. And so after you go to your answer hearing, the tenant will be approached by the judge, or the judge will call the name of the case and say, hey, do you admit or do you deny the allegations in the petition? That's not that at the answer hearing, that is not the stage to kind of bring all of your evidence or to put on witnesses, or to say, hey, no, this is a huge misunderstanding, or hey, I didn't even get a notice. What the heck? This is purely just the judge wanting to understand whether or not we need to have a trial setting to resolve whatever dispute there is, or if we're all in agreement that, hey, yeah, I admit the allegations in the petition that I owe my landlord $500. If there's no disagreement about what's been filed and everybody agrees, well, then the judge will say, okay, great. They'll stamp their little book, and then a consent judgment would have just been entered in, and then you're kind of done with your whole eviction case, as far as your opportunity to put on evidence or anything like that. If you admit at the answer hearing, then you no longer pass go. You don't collect your $200. There's no trial. There's no additional setting. There's just, that's the end of it. You agreed to the contents of that petition. If there was money to be owed, then you consented to owing it. And then the sheriff's department could theoretically come within 14 days and remove you if the landlord were to request, some sort of a writ of restitution to enable them to remove an individual from a property. But if you deny, then, and if you have any basis to deny, so that can be, I didn't get a notice, or, I don't actually owe $500, I owe $400. Like if there's any reason for a tenant to challenge the contents of that petition, whether it's, some sort of a factual allegation in the petition itself that says, the tenant was non-compliant with the lease agreement by, ripping all the copper wiring out of the walls or something like that. And that didn't happen, but maybe you are behind in the payment of rent. Well, you can still say, hey, I deny. I didn't do that. And, you may have an opportunity to try to mitigate those alleged damages that they're trying to attribute to you. And we'll talk about that here in just a second as well. But the thing I really want to make sure that you guys hear is that if you deny, then the trial date has to happen within 14 days after that answer hearing. Ooh, 14 days. So that's 2 weeks after your initial answer hearing of where you admit or deny. So we are talking about like a 28-day period from like life cycle generally of these cases, less than a month. Well, unless we're talking about February, then, then it's a month. But that's how breakneckingly fast these things can move, is that, from start to finish, we're talking about less than a month period of time that has to pass from, the landlord paying the filing fee and all that good stuff to when, a potential trial could happen and a judgment being rendered. You can see how there might be some concerns, so to speak, on the part of a tenant. If they don't already have all their evidence or their ducks in a row, as far as like, well, how can I tell my side of the story? How can I present my defenses if I don't already have some of this kind of pre-baked or readily available? Because your ability to, facilitate getting maintenance requests and things like that from a landlord are going to, kind of be dependent on A, their ability to keep it, but B, doing some sort of a shortened discovery process, to facilitate actually getting those. Because I'm sure we're all kind of like, in the legal profession and stuff. I'm sure that, we've all seen NCIS or like Law and Order or things like that, where, the other side has to give, you their evidence as far as like what they have against you and all that stuff. That doesn't really have to happen here. For a landlord tenant case and for a landlord to prevail in like a non-payment of rent type case, for example, really all they have to show is that there's a lease agreement or some agreement to pay rent, that there's a ledger showing that that payment wasn't made, and then that they gave a notice to, either pay the alleged balance or to get out of the unit. And if they can show all three of those things more often than not, they've satisfied their burden in order to request damages for a non-payment of rent case, in an eviction setting. So that's something to really keep in mind versus a tenant if you're going to be arguing about, some sort of maintenance thing that hadn't been fixed or what have you. You're going to be needing to supply a lot of that evidence, on your own front by keeping records of those documented requests or correspondence. And again, I'm getting to it, I promise. But I just really wanted to make sure that I shared with you guys, if you hadn't heard this timeline kind of thing before, that 28 days from beginning to end is so fast, for someone to be able to put together, their whole defense as far as, what's happened. Because a lot of times, these folks have been living in a particular place for years. And so sometimes this can be a fairly expansive claim. And so it's one of those things where you really need to be promoting to tenants that they need to be gathering their information and preparing for a fight that hopefully they never have to have. But if they do have to have it, that they're armed and ready to engage in that if it comes to it. So yes, so this is what I was talking about insofar as, the shortened discovery timeline, as far as, there are mechanisms in the law, right, that if there has been a lot of maintenance requests made, or there's been emails exchanged, but maybe something, your email got hacked and you can only get those correspondence from the landlord. There are ways in the law to request shortened discovery, or to send interrogatories to the other side to have them, specifically admit or deny particular facts or claims. But that is a really, it's not to say that it can't be done by pro se litigants. People do that all the time, but it's just creating another, network of things that a tenant would need to be aware of at the onset of their court case in order to give them enough time, as much time as possible, to kind of facilitate this process if they aren't doing it ahead of time. So I guess what I'm trying to say is that yes, there is a mechanism in the law to try to request this information to be shared, or to have the other side answer some difficult questions, perhaps. But it's one of those things where you need to make sure that you're in strict compliance with these statutes here, and that also is, assuming that a tenant has kind of that baseline knowledge as far as what those necessary legal documents to file, to request that information from the court. And so again, if we're in the business of trying to prepare, tenants to be as successful as possible as navigating these situations, we want to try to encourage them that to, have a safe folder, or a safe known place where they can put all of that information just as it continues to accumulate for them, as far as, those notices that get taped to the door, or if there's been like an email communication with a landlord, that they're saving that in some sort of a folder, or if there's receipts for, pest control things that they're paying for that the landlord should be responsible for. All of those things that a tenant is in control of as far as, they're part of that communication. We want to try to make sure that we're instilling some level of, hey, make sure that you're keeping this readily available in the event that it comes up later, that where this information is in the event that you need to have access to it. And most importantly, I know like I've said that before, but I'm going to keep getting as much mileage out of that as possible to try to signpost for you guys here at 9:43 in the morning. Please, please, please tell your tenants to deduce everything in writing. It doesn't matter if you're renting from mom and dad, from Uncle Joe, from corporate landlord. If you're having a communication with the property manager or a maintenance person or the head honcho, and it's just, even if it's in passing, if it's something that is of substance, hey, thank you so much for, or, if you're getting permission to pay late, or you made a maintenance request, send a follow-up email that just says, hey, thank you so much for chatting with me today, and for agreeing to send Jason to my unit to look at my furnace, or thank you so much for giving me permission to pay my rent by, the 11th of March rather than on the 1st. Just so that you are creating a record of that communication, because you don't want to find yourself in any kind of a court setting where you're relying on testimony, which is certainly admissible and that is certainly evidence that can be used. But I think that we can generally agree that, if you have those emails that also substantiate what you're saying, plus the testimony, it just gives a lot more credence to it. And it makes it more than a he said, she said. It becomes more of a, well, hey, no, this is what happened. And then this is the email that I sent that followed up, kind of confirming that with this individual. And then if that individual doesn't send something, to the contrary, well, then it's, well, hey, I told them what my understanding of the situation was. It's here. It's in this email. They never responded. They didn't correct it. They didn't give any kind of, alteration to that understanding. And so, this is why I did what I did. That creates a much more favorable situation for a tenant, than just going on the stand and saying, oh, yeah, we talked, somewhere around the 9th of March about me getting an extension to pay maybe by the 11th. You can kind of see how, like, the email that has the date and the time and the sender and all that good stuff, that carries a little bit of a different weight to it. And so if you have those written communications, even if it's a text message, those are fine. That counts as a writing. Just create that record for yourself. So again, hopefully you have it, and hopefully you won't need to use it, but it's there if you do. Okay. So we've kind of been talking about this, overarching, throughout our previous couple slides. But obstacles for tenants in court. The first one, believing the landlord's word over the tenants when there is no other evidence. That's definitely where your emails or your notices or lack thereof can come in handy. And they do that legwork. They bridge that gap, because I'm going to share a dirty little secret with you guys. Are you ready? Make sure my door's closed. Judges don't usually hear the tenant's side of the law. Okay, I know, like, that might not be the most ground shaking revelation that we've all heard, but tenants usually don't have the resources to pay for representation. And so that usually results in some, level of Googling or some level of frantic, legal research, and trying to present, the statutory protections that we've been talking about in some form or fashion. But the level that these judges are hearing landlord side of the law, landlord arguments, because landlords generally are represented by attorneys, is so much more than what the tenants have on that same side of the coin. You hear me? So, the articulation of the duties of the landlord, right? And I have a whole slide dedicated to that. But, saying that, hey, Judge, there's a statute here that says the landlord is explicitly responsible for having reasonable amounts of hot water and running water at all times. There's a statute that says that. This is the statute. Boom. Like, I didn't have running water. Here are the receipts. Here are my maintenance requests. And so that's something to keep in mind, that, as you're trying, or as tenants are trying to articulate what their defenses are, having that additional support to, embolden the judge to feel good about siding with the tenant, even though it shouldn't necessarily have to be that way. There's a comfort level that a lot of these judges have on the bench as they're looking at these claims and as they're evaluating the various defenses, or, the contributors of how we got here. There is a comfort level with some aspects of the Kansas Residential Landlord Tenant Act. And then there's some parts of that act where maybe they've never even heard a tenant try to articulate a defense based on that. So that's just something to kind of keep in mind, that, there is that little bit of a disconnect there, in that if you have as much evidence as possible to kind of bridge those knowledge gaps for the judge, or if, we're talking about it like an administrative hearing, for example, with Section 8 or something, this is this type of evidence that they're going to want to see to feel good about, okay, yeah, I see the statute that you're trying to articulate. I see the evidence that you have that kind of goes in hand with that claim. Okay, cool. I feel comfortable and going and siding with you, tenant, on this particular issue. The financial issues, again, I kind of touched on that as well, that, generally speaking, more often than not, our type of landlord tenant disputes are coming from some sort of a non-payment of rent issue. I'll talk about the other stuff here in just a moment. But, if you think about it, if a tenant is having problems paying monthly rent, even if it's a matter of, maybe they're withholding it, which you're not allowed to do in Kansas. And again, I'll scream that from the heavens here in just a second. But, generally speaking, if you're on some sort of a subsidized lease agreement, if you're on some sort of project-based Section 8 or something like that, well, your ability to go out and hire a private attorney to defend your interest and to articulate your point of view, that's going to be a lot harder to do than like a corporate landlord who maybe has, an attorney on retainer who does, dozens of evictions for them every month. So that's kind of something to understand as well. And then the confessing liability at the answer hearing is something that we see happen all the time, because a lot of tenants, as they kind of work their way through the process, a lot of people don't have a lot of experience with the court system, as far as, going in front of a judge and being asked direct questions in a room full of people. Heck, that's super intimidating for me. And I've gone to law school. So, it's something to understand when a judge is asking a tenant, hey, do you admit or deny the contents of the petition? While that is how, judges should typically be asking the question, we have also seen a lot of judges say, hey, do you admit or deny that you are delinquent in the payment of rent, or that you're behind in the payment of rent, or that you owe the landlord $500? Well, that puts a tenant who's not super comfortable in the first place in kind of an uncomfortable situation, especially if maybe they are behind in the payment of rent, but maybe they're not behind by 500, maybe they're behind by 300. And as we said before, if you have a basis to deny, you can deny. You don't have to articulate, you don't have to expound upon it. But depending on how that question is being asked and the setting that a tenant finds themselves in, that can certainly create a situation where maybe they feel induced, or they feel internal pressure that they don't want to be dishonest or or find themselves in some sort of hot water with the judge by, well, I don't want to be cute with it. Yeah, I might owe some money, but it's not that much. But the judge is asking if I owe anything. Well, yeah, I'll just say that I owe money. Well, okay, if you say that, then again, you're confessing liability at the answer hearing and you're consenting to a judgment being entered against you. Okay, so now we're going to talk about our notices here, as promised. So I had kind of touched on, and I'm going to give like the general, like just a quick overview of each three of these, and then they each have their own individual slide. So the 3-day notice is only for non-payment of rent disputes, okay? And that's regardless of the type of tenancy. If there's an alleged non-payment of rent problem, as far as, if it's late or what have you, this is the notice that has to be issued to a tenant in order for the landlord to escalate that to the next level, to bring the court in. The next level, or the next type of notice that we see, are these 14 30-day notices. These are for any other type of non-compliance with the lease agreement. So that can be, you're playing music too loud, you have an unauthorized guest, you have an unauthorized pet, you are smoking in the unit, things of that nature, where, it's anything other than the non-payment of rent, level of dispute. And then the last that we kind of talked about at the very beginning is this 30-day notice for a month-to-month tenant. And that is, typically only reserved for these month-to-month tenants. That's, no fault of either party or anything like that. I'll go into more detail here in just a moment. So the 3-day notice has to, and I need to come up with a new catchphrase to kind of create some attention, throw some red flags, throw some alarm bells. Bing, bang, boom. That the 3-day notice has to have specific language in it to be valid, okay? It cannot be just like scribbled on a piece of paper, you have 3 days to pay or you're out. That's not good enough. It also can't say, you owe me $500, pay it or you're evicted. It can't say that either. There is case law that says that these notices have to be in strict compliance with the law. And what that means is it can't just be good enough. It can't be close enough, or what we call substantially compliant, where it complies with the spirit of the law, but it maybe doesn't say the exact thing. No. It has to say these specific things. It has to give the tenant notice to leave the premises, and that meaning, hey, tenant, you have 3 days to either pay the alleged delinquent amount, or you have 3 days to leave the premises. Okay, it has to give you both of those options. It has to give you 3 days to do both of those. And failure to do either of those things, so failure to pay or failure to leave, will result in the termination of your tenancy, and then it can lead to further eviction proceedings. Okay, so it's got to give you the 3 days to pay, it's got to give you the 3 days to leave, and it has to say that if you don't do either of those things, then your tenancy will be terminated. Okay. If we were in person, I've got a couple of Hall of Shame notices that I've collected over my 3 years here at Kansas Legal Services. That landlords have attempted to use in court as part of their efforts to evict people. And judges have looked at them and said, no, this isn't compliant with state statute. I'm dismissing the case. And again, like we talked about before, while that's awesome and the dismissal is great, and that's definitely part of that controlling of the optics thing that we talked about earlier, that record of that eviction case being filed is still there. And so that's something to keep in mind, where you need to make sure that if the case results in some sort of a dismissal or something of that sort, that the tenant has a copy of that dismissal in that manila folder or in that record. So that way they can pull it out and explain to their future property manager, future landlord, hey, yeah, you might find this record about me, but here is this kind of, explain away card that the judge threw the case out and I didn't actually end up being evicted. Now, another thing to kind of keep in mind about these deficient notice arguments is that this is not like a be all end all argument. It doesn't keep this from happening again. It just means that the landlord has to try and reissue a new compliant notice. It kind of gives the tenant, it flips that taboo timer over and gives them additional time and resets that whole timeline of the process to either, work something out with the landlord, get on a payment plan, find rental assistance, or to, relocate or come to some agreement to, pay something. And then, hey, if I'm out by the end of the month, can we, just, be done with this kind of process? It creates more opportunity to problem solve, so to speak. And so again, like I said, this is not something where the court necessarily has the latitude to say, oh, that's good enough. Again, there is Kansas case law that specifically says, and it's from even the 60s. It's long held. It's been established. We argue this case, this Gooden v. King case, all the time in Wyandotte County, as far as, hey, there's no subject matter jurisdiction here because there was not that valid notice issued to the tenant at the beginning. Therefore, the court has no jurisdiction over this case. Okay. So these 1430 notices, there's a little bit more going on, but I want you to just think about them in the context of that these are for everything other than non-payment of rent. And these are usually in the context of, the violations of like a tenant handbook or something. When you move in and they give you like the list of rules that say like, hey, quiet hours will be, Monday through Friday, every night after 9:30. It's not, you can't be loud or having parties or what have you, or, you have to have a pet deposit, if you're going to have an animal or anything like that. What these are for and kind of how they function is, if there's a situation where, I find a puppy or something in the parking lot, yay me. But I don't want to pay the pet deposit, and I just take the pet, I take the puppy into my unit, and I say, hey, cool, I now have a dog. Well, then if management finds out about it, they can issue me one of these fancy 1430-day notices that say, hey, Mr. Mo, you are out of compliance with your lease agreement by having an unauthorized pet. You have 14 days to remedy or make a good faith effort to remedy. That's an important distinction. It's not that you have to actually 100% cure the alleged defect, but you have to make a good faith effort to remedy that within 14 days. Or if you don't do anything, then the tenancy will end 30 days upon receipt of that notice. Okay. So this again kind of ties into why it's so important to have these written communications. Because if you do your effort on day 15 or day 16, well, hey, that's cool. You didn't do it within 14 days and your tenancy is still going to end within 30 days. So that's why it's so important if you find a tenant that has one of these 1430-day notices, that one, they keep it, And two, that they engage in an email or text message or some sort of written response with their landlord that says, hey, I received the notice. This is what I did to remedy it, and I consider the matter resolved. That there's some sort of record that they did something within that 14-day period. Now, something else to note too is that if you commit the same or a substantially similar breach, and you've already gotten a 14 30-day notice, then they don't need to give you another 14-day opportunity to cure. So let me put this as an example, and then I know that I'm kind of running up against my time, Rhea, and so I'll just kind of try to get through this slide. And anyone who can continue onward with our awesome presentation, then you're welcome to, and if not, my feelings won't be hurt.
Yeah, you're
Um,
totally fine. We record it and we'll post it on our website eventually. So you're
oh,
totally fine.
lovely.
We do have a question really
Yeah,
quick. Does the 1430 have to state the steps for correction?
no.
Okay.
If
And
it
then,
does,
oh,
that's
sorry, go
super
ahead.
helpful, but it does not have to do that. No.
Okay. And then one more question. Do they have to cure it or only begin to make efforts to?
So that is an awesome question. And the answer for curing, they don't have to 100% cure. And I'm just going to read you the specific language of the law here as it pertains. And both the landlord and a tenant can issue one of these, by the way. I'll kind of talk about what that looks like for a tenant. Um, but the specific language is that if the breach is not remedied in 14 days, because it says, okay, yeah, except that if the breach is remediable by repairs or the payment or of damages or otherwise, and the tenant adequately initiates a good faith effort to remedy the breach prior to the date specified in the notice. So it can be a matter of like on day 14, if you say, hey, I ordered a muzzle for my dog who allegedly maybe nipped at somebody in the lobby, or, on day 14, it can say, yeah, I enrolled my dog or my animal in the process of becoming a service animal. They need to take meaningful steps to actually resolve the alleged issue, but it doesn't need to be 100% cured within the 14 days. They just need to initiate that good faith effort to get that issue or the alleged issue resolved. Um, and so what I was saying too about consecutive 14 30-day notices, like if you end up committing the same breach, right? So with my puppy example, if I got a 1430 for having an unauthorized pet, in March, and I fix that and life is good, but then in November I find a pack of stray kittens, and I choose to bring them into the apartment and again try not to pay a pet deposit. Well, then the landlord doesn't need to reissue me a new 1430 because having an unauthorized pet is the same or substantially similar 1430 violation that I allegedly did in March. Now, where it can kind of come to effect is with the puppy happening in March, I got the 1430, but then let's say in October, I my landlord is starting to get on me because I'm smoking in my unit or something. Well, smoking in the unit is not substantially similar to having an unauthorized pet. So I am entitled to a new 14-day cure period to stop smoking in my unit. Does that make sense? Okay, perfect. I see some heads nodding. We'll rock and roll with that. Um, is this okay? Before I go to the 30-day notice, the 1430, I mentioned that, while only a tenant necessarily pays rent, right? So the 3-day notice is going to be kind of reserved for a tenant to receive from a landlord. A landlord can receive a 1430 from a tenant. And I actually did this recently for a couple of clients, where, if the landlord is doing things or not fixing things, that are out of compliance with that lease agreement or out of compliance with the Kansas Residential Landlord and Tenant Act, then a tenant can issue a 1430 on a landlord, putting them on notice that, hey, you have 14 days to, fix the weather or the ceiling on my door, that doesn't seal all the way, or to fix the collapse water spot in my ceiling, or to fix my furnace, or insert maintenance issue here. If you don't, then my tenancy will end in 30 days and I'm leaving. That is something that a tenant can do. However, I do want to make sure that I flag this as a little bit of a cautionary tale because um, you're kind of initiating a game of chicken with a landlord, so to speak, right? Where if you don't have that next lily pad opened up for you or a place to go, you could theoretically be initiating your own or signing your own pink slip, so to speak, as far as giving that landlord the jurisdiction to take a case to the court and say, hey, this tenant said that they were going to be out of here within 30 days if I didn't do something. Now, that's a dangerous game for a landlord because the basis of the termination of the lease is the landlord's alleged breach. But that is something to keep in mind that like if a tenant issues this to a landlord, they're saying that they will be out of there within a given period of time, um, or they are threatening to be out of there by a given period of time, and that can potentially create an uncomfortable situation if they don't have a place to go. So using this as a tool is something that is available, but something that should be kind of mindful as it's being deployed. Okay, now the 30-day notices. Um, Again, this can be used for any reason. Either landlord or tenant, like we talked about with the 1430s, can issue this, and it doesn't have to be based on any kind of non-compliance by either party. Again, month-to-month tenants and tenancies serve a purpose, right? If you're new to an area or you move into a place, but you know that it's not your forever place, you're going to be continuing, maybe you're starting a family or what have you. If you're in any place that you think you're going to be there for less than a year, then perhaps a month-to-month tenancy makes sense for you because you want that flexibility. You don't want to be tied down to a full 1 year lease term. But if you're going to be staying any place and you don't have intentions to leave and you're thinking you're going to be there indefinitely, it is much better to position yourself to be in a 1 year lease agreement just so that you don't find yourself on the on the receiving end of a 30-day notice and there's nothing that you can do and there's no necessarily prep that you can do in relation to that. Something to kind of illustrate this. We had a situation a couple years ago at one of our help centers where there was an elderly tenant who was living in a duplex, and she had lived there for over 12 years, I want to say. And the landlord lived in the other side, and they were good friends, and that was totally fine. Life was good until the landlord passed away. Well, the landlord passed away and the property passed to his children who had no intention of wanting to be landlords and they wanted to sell the property. Well, the applicant had not signed a lease agreement since her initial lease was signed, 12 years prior. So she was on that month-to-month tenancy. She received a 30-day notice and had to leave. There was nothing that could be done as far as, saying, hey, well, she's been here for 12 years. Hey, she's elderly. Insert all of those kind of relative, considerations for people who have to move, there's nothing that could theoretically be done. The notice was valid. She had received it. And so, it was one of those things where there just wasn't that additional protection. There wasn't that additional, basis that a landlord had to assert in order to terminate that lease agreement. It's not as though they terminated it early, because it was on a month-to-month lease. They could issue it that termination notice at any time as long as it was a 30-day notice tied to a rent paying day. But again, it's one of those things where if you're seeing individuals who are operating on their month-to-month lease, but they're talking and acting as if they're going to be there for years, well, then it's one of those things to just kind of maybe be that voice in their ear saying, hey, look at your lease agreement, make sure that automatically renews on a 1 year basis. And if it doesn't, maybe you need to ask to re-sign a new lease or renew your lease. And so that's something to also keep in mind. Okay, so, and I promise I'm almost done. I've got the last slide is a Q&A one. So these ones are going to be dealing exclusively with court actions and counterclaims, and the duties of the landlord, like I was talking about before. So if you find yourself or you're helping a tenant that is dealing with a non-payment of rent-based eviction, so again, anything other than your 1430s, okay? You have to counterclaim for any available damages that you have under the lease agreement or under the Kansas Residential Landlord and Tenant Act. Otherwise, those damages or claims are waived. We call that in the business a compulsory counterclaim. And why that is the why that is the reason that it is because the court does not want to go ahead and issue a judgment for a landlord based on non-payment of rent. Okay, Timmy tenant, you owe Larry landlord $500 for non-payment of rent. But then next year, if Terry tenant files a small claims court based off of the ceiling collapsing in his unit and maybe not having running water for a while, well, we've already issued money saying that you owed this party this much money underneath this contractual scheme. We don't want to have to re-upset that apple cart and then maybe have that party, pay money to the other party that we've already held liable for something. So the court wants to have all of those claims handled at the same time. Okay, if there's money going to be changing hands, and again, if it's a non-payment of rent-based eviction, then you have to have a counterclaim asserting all of those claims. Otherwise, they are waived. Okay. And our most often basis for counterclaims are usually these statutes here. Again, I tried to keep my keep the presentation away from statutory numbers as best as I could, but these ones are kind of the hot button ones that I think you guys should kind of be on the be aware of. The habitability issues. This statute specifically deals with the duties of the landlord, and I have my next slide is about that. The attempt to enforce prohibited lease terms, that's like what I was alluding to at the very beginning, that all of the protections of the Kansas Residential Landlord and Tenant Act are read into every single lease agreement, even if they're not explicitly printed on the back of every one. And so if the landlord is trying to skirt those rules or skirt those protections, this is the statute that they are violating, this 582547B. The removal from a premises or diminished services, that would be a situation where if like a landlord is, shutting off utilities, or if they're refusing to fix, a bathroom or something, and that way, the tenant effectively doesn't have, they don't actually have two bathrooms. They might have a lease for two bathrooms, but because there's mold or because the sink doesn't work or the tub is backfilling with, nonsense. In practice, I really only have one bathroom as opposed to two. And so I'm being unlawfully removed or excluded from my entire premises because of the landlord's inaction or inability to fix something. And that can be like a guest room, bathrooms, anything like that, where if the landlord's inability or unwillingness to comply with state statute is resulting in a tenant not being able to get full use and enjoyment out of a property, they're in potential violation of 582563. Retaliation, that's kind of, hey, I filed something with code enforcement and now I got a 1430 or I got a 3-day notice for something. They're retaliating against a tenant for utilizing their mechanisms, whether it's local, state, federal, as far as trying to hold these, the parties responsible for their obligations. And then the landlord's trying to terminate that rental agreement as a result of the tenant exercising those rights. And then unlawful entry, it's important to remember that, a landlord, they have the right to access to a property if they give reasonable notice. Okay. And reasonable, there's not really, good case law. That's where attorneys make all their money, is like, well, what really is reasonable? What's not reasonable, and I think we can all agree, is if a landlord just comes into your unit without providing any notice and then just starts doing things. Now, there is, the exception to that where, like, if there's flooding or something like that, or if there's a fire or some sort of an emergency situation that, a property manager or a landlord needs to get into a unit to address, shut off the water or what have you, that's okay. But if it's a situation where there's like a dispute and the landlord is, taking all of a tenant's belongings and putting them outside, for example, that is definitely illegal and in violation of several of these statutes. Okay. So the reason why 582553 gets its own slide is because this one is so expansive. And this is just kind of paraphrase the statute. But the biggest ones that we see a lot of violations with is this compliance with the local codes materially affecting health and safety. So that can be, if there's like a rental licensing scheme
like here in Wyandotte County, if you want to be a private landlord, you actually have to apply for a license through the Neighborhood Resource Center. You have to have your property inspected, and then you pay some sort of a fee. You get a license to be a private landlord in Wyandotte County. And then you have to be compliant with these codes, in different intervals as they continue to do inspections of those properties to make sure that people are living in safe housing that is compliant with, building codes. Um, but the statute goes a little further too, because in some rural areas of the state, maybe they don't have a robust code enforcement, maybe they don't have building codes or what have you. So the statute provides additional protection, saying that the landlord also has to provide working electrical, plumbing, sanitary, heating, ventilation, air conditioning, appliances that are supplied or required to be supplied by the landlord. So that's like kind of a long-winded way of saying that if the landlord gives you a dishwasher, if the landlord gives you a garbage disposal, if there's a fridge, if there's a washer dryer, all of that stuff has to work. Okay. And it has to be in good working order for the landlord to be compliant with their duties under 582553. The other side of that too is that like all of the light switches have to work, all of the outlets have to work, the ceiling fans, all of that stuff, all of the plumbing has to be in good condition. There can't be any of this random, sewage backing up into the tub and thinking that that's okay. That's not acceptable and that's not allowed. Even if that's something that, the local codes maybe don't address, the state statute does have explicit language saying, hey, all of these things need to be up to snuff. And so the local codes is local code enforcement, right? Those building codes. And so in Wyandotte County and in a lot of cities here in Kansas, I believe that Topeka and Lawrence and Leavenworth, a lot of the areas that we do a lot of practice with, they use the International Property Maintenance Code 2018 version. This is actually it here. It's not that big. I mean, I know that my camera is having some issues focusing. But I believe it's only 6 chapters long, and I printed the entire thing, and it was less than 80 pages. So it's not like a super expansive, it doesn't address mold. Unfortunately, I was looking into that the other day. But it does set like the baseline things for like ventilation, as far as like how many windows need to be in a given space, how many occupants can be in a particular space. That all of like, the surfaces for interior surfaces need to be free of like chipping paint and those sort of things. It sets the backdrop of the baseline, the International Property Maintenance Code, that is. And then it's not uncommon for municipalities to adopt additional ordinances on top of that are maybe a little bit more strict than like the baseline code itself. A resource that I wanted to make sure that you guys were aware of is that the Muni Code Index. This is a website that has a lot of the city ordinances, not just building codes, but like ordinances in general are uploaded on this website. And when I was an intern with the code or with the League of Kansas Municipalities, I used this resource quite a bit to just check on like how ordinances were different, from one city versus another, because maybe there is a local rule on one thing in one jurisdiction, but there's not in another. So as you're kind of looking and trying to articulate what specifically is wrong with units, this can be a resource for you as well. The Neighborhood Resource Center I had touched on a second ago, they are kind of the code enforcement body in Wyandotte County. There are similar organizations, in some of the other cities across the state that operate, to handle, like if there's like tree removal or things for older residents. Like they handle that stuff as well, but they're the ones who handle all of the rental licensing and code enforcement procedures in Wyandotte County. And then of course, like your local code enforcement officials are people who you want to make sure that you have a good relationship with if you're going to be assisting tenants and articulating what exactly is wrong with their units, and trying to help them prepare for any kind of a counterclaim or future court action that they might have. Okay, so again, this was not meant to be the expansive, let's talk for an hour and then you guys can go into the world and be, absolute experts on all things landlord tenant law in Kansas. But this was meant to just hopefully be a primer and make sure that everyone here is aware that there are rules that exist and that there is a scheme in place that landlords and tenants have to abide by if they're wanting to utilize the court as part of their dispute resolution process. But also just trying to make sure that there's an understanding as far as like the different dynamics that can be at play as tenants kind of work their way through their relationship with their landlord. If there are any questions, I'm happy to answer that. I know I ran over a little bit. But one last resource that I want to make sure that I'm sharing with you guys is Kansas Legal Services has pre-made forms for tenants if there are maintenance request concerns, if there are, payment under protest, because like I mentioned before, tenants are not allowed to withhold the payment of rent, in the state of Kansas, even if landlords are not in compliance with their duties here. That's why it is so important that, tenants keep track of all of their maintenance concerns or requests, because that's oftentimes what they are counterclaiming for. In these compulsory counterclaims, they're saying, hey, my lease agreement is $500 a month for a unit that is in complete compliance with all of the state statutes. I have been living in this place with no running water for 2 months. The value of that unit is not $500 a month. It's actually $100 a month, or it's zero, or it's whatever the tenant wants to try to articulate as far as what their contractual damages are. Because in Kansas, in state law or case law, has set out that these damages that a tenant can request, and as part of these counterclaims, is the difference between the fair market rental value of their unit as set out by their lease agreement and what the actual damages or what their actual value of that unit is. So, again, if you only have half of a bathroom because the sink doesn't work, well, then you shouldn't be necessarily paying full freight and cost for an apartment that only has 1.5 bathrooms when the lease says that it has 2. And so that's part of how those damages are calculated and asserted in any of these counterclaims. Okay, I promise I'm done now. Are there any questions or anything like that hopefully I can help answer?
Yeah, feel free to put them in the chat as well.
That's all.
Alrighty.
And I'm going to put because I thought that I had it at the bottom here. I'm just going to throw my email in the chat too. If anyone has something that comes up later in the day, hey, what did that funny guy with the glasses say? He was talking really fast. I'm happy to be a resource. Like I said, I want to be as available, and Kansas Legal Services wants to be as available as possible. As we kind of try to equip tenants, to hopefully navigate this situation as painlessly and productively as possible.
Thank you so much, Chris. Oh, looks like we got a question. Can landlords require tenants to obtain rental insurance?
Yes.
Okay.
Can. And I have seen I've seen that before, and typically those landlords who require that, they have some sort of an in with some local insurance, or they offer some sort of like in-house insurance policy that they want to try to have added on to the lease agreement. Presently, there is no sort of like law or anything that prohibits that particular practice.
Thank you. Any more questions? All righty. Well, thank you so much, Chris, for giving that great session today. It was very, very helpful and valuable information. We, again, just kind of to recap, we do get the recording of this webinar on our website within the week. So check there. I put the website in the chat earlier. Please feel free to visit that and share it with your colleagues. And you can also find some of the past KLS webinars there as well. So thanks again, everyone, and I hope you have a good rest of your day.
Thank you, guys.
Yeah. Thank you all.